Good morning.
Good morning. May it please the court, I am Marcus David Benedetto, son of the deceased. I want to thank you very much for giving me this opportunity for oral argument. I understand that it's not an obligation. It's a choice of yours, and I appreciate it very much. I would also like to say that if I make a mistake, I would appreciate it if you would correct me, because I don't want to lose on some rookie error. I'm not a lawyer. I would like to lose on merits.
Okay, we understand that that you're pro se and that you don't have a lawyer, and we'll certainly listen and give careful consideration to what you have to say. So tell us.
Appreciate it very much, sir.
Just begin by telling us, start with the issues that you presented and explain those to us, if you would. And if we have questions, we'll kind of jump in and ask you. Okay.
I would also like to request half my time, 10 minutes for rebuttal.
You want 10 minutes for rebuttal? Okay,
yes, sir.
Very good. I'll remind you when you get your 10 minutes.
Thank you, sir. What was your original question? I'm sorry.
Well, let me just start by asking a question.
Okay, good.
Your initial brief really didn't address the two issues that the trial court ruled on, and would you agree that under Rule 1.540 you're time barred from moving pursuant to that rule to have the judgment set aside for fraud?
You're allowed to have a separate independent action, which I...
Okay, but there's the rule, and under the rule you're beyond the year period, correct? So you recognize that you can't file for relief under Rule 1.540, correct?
It gives a specification. You can do it if it's a separate action.
Well, okay, let's talk about that. The rule does mention a separate action. The case law interpreting the rule says that the independent action is only available for extrinsic fraud and not for intrinsic fraud. Did you review those cases?
I'm not that clear on the difference between the two. To me, extrinsic and intrinsic mean, extrinsic means what they do to the outside, intrinsic means what they do on the inside. Outwardly, they told us they were a nursing home. Inwardly, they told the courts they're not a nursing home, they're a hospital. In that regard, it seems rather simple and yet rather confusing that this can be so. Under one circumstance, they are...
Assume now the case is and we're bound by the laws set forth in the rules of civil procedure and, of course, promulgated by the Supreme Court and case law. And the cases that discuss this talk about extrinsic fraud in terms of things that keep you away from court. In other words, someone telling you that, oh, no, we haven't filed a suit against you, so that you really don't have an opportunity to respond and be a part of the lawsuit. Intrinsic fraud would be a fraud perpetrated during the lawsuit. In other words, representing something during the course of the lawsuit in which a party is participating as true that is not true. And assuming that that's the definition that we're bound to deal with, it appears to me that you're relying on the Schenck affidavit as incorrectly stating, or fraudulently stating, that this facility was not a nursing home when in fact it was. It would appear to me that that would be intrinsic fraud given the definitions that we have to follow. And if that is true, I just don't see an avenue for you to bring the claim at this time. If the rule doesn't permit you to challenge the final judgment, which would have allowed you to challenge it based on intrinsic fraud if you filed within a year, and an independent action is only available for extrinsic fraud, I just don't see a basis for us to do anything but affirm the trial court's decision that you were time barred in bringing this. Have you tried to look at case law or tried to look at any cases? Because I haven't seen any that would give you an exception or out given the parameters set forth in the rule and the cases interpreting the rule.
I looked at the cases that were referred to in the order, and those refer to issues that I believe are immaterial, where there was the attorneys said he was going to call somebody or subpoena somebody, and he didn't, and so that is what they're referring to as litigation privilege, and minor business issues, not the death of an individual, not a gross lie that carries the weight of the entire case. He said, never been, therefore they're not a nursing home, therefore there's no case. However, he lied on purpose. They accepted her as a nursing home to gain the Medicare funds. However, when sued and for the death of her death because they left a blood pressure cuff on the arm overnight, inflated, they say, oh, no, we're not a nursing home, we're a hospital only. Whereas in fact, they have a dual identity, and a half-truth is a falsehood. Also, with regard to, as you mentioned, sir, about opinions, I would appreciate it if I understand if there's an overturn of the lower court, then you have to write an opinion, and it is not necessary if you affirm. However, sometimes you may write an opinion if you affirm as instructive, and I would appreciate it very much if you would do so, so that I can truly understand as a common individual and understand what happened and what goes on. The question, I did talk to a couple of attorneys, and one of the big questions that came about was, what attorney is going to write, what panel member is going to write an opinion that says it's okay to lie? Because that's essentially what the judgment says. Well, it's okay to lie. You won because of this lie. That's okay. Now, as a common individual, I have trouble buying that. That's like saying, I'm now Superman, I'm now Clark Kent. Sorry if I think it's done once in a while. I'm now Clark Kent. Two different things. No, it's the same individual, same entity. Two different identities, but both identities are within the same entity. Another analogy would be that of the turkey. You feed the turkey during the day and all year long, and he benefits from that feeding and gets nice and fat and happy. Come November, I'm not a turkey, because he now has to pay the price. So there's an old saying, you can't have your cake and eat it too, and I think if you benefit from one, you have to pay the price for that. You accept the liability, stand up, and be accounted for. I believe my understanding of the law is that the person who perpetrates the error or causes the damages is supposed to be liable, and that's the purpose of the law, to prevent them from escaping liability. So I ask your help in that issue. Question, sir. All right. They had a duty. They accepted her. They had a duty to care for her, and they performed all of the acts that a nursing home performs. They had care plan meetings. They had the ombudsman. So on the surface, they told us they were a nursing home. They acted like a nursing home. They quacked like a nursing home. They had meetings like a nursing home. They had called her resident, not patient. And they're a patient in a hospital, a resident in a nursing home. But when it came time to pay the price, no, we're not a nursing home. We're a hospital only. Thank you very much, sir.
Okay, you've got 10 minutes and about 18 seconds left. All right, thank you.
May it please the court. Good morning. My name is Frank Kosaki with the firm of Zuckerman Skater on behalf of appellees Columbia Park Healthcare Systems, Inc., Columbia Park Medical Center, and Jim Shanks. Based on Mr. Benedetto's presentation, I'm going to rest on the arguments raised in our answer brief. Unless the panel has any questions, I do want to point out one case that was decided subsequent to the presentation of our answer brief. It's Parker v. Parker. It was decided by the Florida Supreme Court in February 2007. It hasn't been reported in the reporters yet. I can give you a cite at the Florida Law Weekly. It's relevant to the discussion in the sense that in the context of a dissolution of a marriage proceeding, the Florida Supreme Court discusses the distinction between intrinsic and extrinsic fraud and how that relates to Rule 1.540. And in that case, in the Parker case, the Florida Supreme Court...
Did you file a notice of supplemental authority with that case?
No, Your Honor.
Okay, you can file a supplemental authority as you want. Generally, our rule is if you don't file a supplemental authority and it's not in your brief, we don't let you argue it at oral argument.
Oh, okay. Unless the court has any questions, I can briefly go through the history of the proceedings. In short, Mr. Benedetto and appellants have had ample opportunities to raise their issues. This case was originally filed in 1998. The trial court dismissed with prejudice. Mr. Benedetto appealed that. This court affirmed. He brought the case below. That the trial court then again dismissed with prejudice, and now we're here. And for the reasons raised in our brief, we feel that appellants failed to make a proper record. Apart from that procedural issue, substantively, they are barred by time under Rule 1.540. They're barred by the litigation privilege. And to the extent that they've raised arguments now in appeal that weren't raised below, such as the Equal Protection Clause argument or parent agency or any issues as to discovery, there's no record below, there's no ruling below, those issues weren't presented below. And as the court is well aware, you can't raise something on appeal from the perspective. Thank you.
Okay, thank you very much. Mr. Benedetto, we'll let you come back up, and you've got 10 minutes and 15 seconds.
Thank you, sir. First of all, there has been no second quote-unquote bite of the apple. This has never been heard by a jury. I would request that opportunity. They need to make that determination whether it's a nursing home or a hospital or what their identity is, number one. Number two, the issue of litigation privilege was referred to in the cases that were referred in the order as minor issues, not material issues of fact that would make a case flip-flop one way or the other. In that regard, you have a ruling that says there is an obligation for candor toward the tribunal, and that candor was blatantly ignored. This falsehood was made purposely, fraudulently. And in that regard, I believe the fraud was perpetrated both directions, toward the court, in which I feel the tribunal should be incensed that they would be lied to blatantly, and I certainly am incensed that I was lied to blatantly for the purpose of gaining our funds, our alleged faith that we were going to be cared for. We relied upon their statements. We relied upon their action that they were in a nursing home, and to our detriment. And if they had not lied the first time, we would not be here today. So, appreciate your help very much. I think please consider the concept. If you can't necessarily have your cake and eat it too, I've asked some form of equity and opportunity to rectify this injustice. Thank you, gentlemen.
Okay, thank you very much.